employee to prove any of this, end of quotation. Notwithstanding the position of the law, Notwithstanding, the position of the law is that when the defendant fails to file a statement of defense, he is taken to have admitted the facts pleaded by the plaintiff. See Consolidated Res Ltd versus Abofa Ventures Ltd and Nigerian Shipbuilders Ltd and Tamuno citations all provided where a writ of summons and statement of claim are filed and served on a defendant, and the defendant fails to put an appearance and file a statement of defense attacking or contradicting the averment raised in a statement of claim or oral evidence given at trial, the court ought to take the facts as uncontested. CCBN versus Okoje. In considering this claim, there is a need to consider the legal status of the parties before the court, as this is a foundational for the effective determination of this suit. The term employer under the interpretation schedule of the Labour Act means, and I quote, any person who has entered into a contract of employment to employ any other person as a worker, either for himself or for the service of any other person, and includes the agent, manager, or factor of that first mentioned person and the personal representative of a deceased employer. See Onumalobi versus NNPC. Under the same act, a worker is defined as any person who has entered into or work under a contract with an employer, whether the contract is for manual labor or clerical work, or is expressed or implied or oral or written, and whether it is a contract of service or a contract personally to execute any work or labor. See Phoenix Motors Ltd and MPFMB and Coca-Cola Nigeria Limited versus Akinsoyam, and also NURTW versus Ugudu. Citations are all provided. By virtue of paragraph 2, 3, and 4 of the statement of fact, it was averred that the defendant is a company and has a factory at number 63/65 Oladipo Otesanya Street off Ijegun Isolo Road, Fagbile Estate, Lagos, where it manufactures paint solutions and plastics for commercial purposes. The defendant employed the claimant to work in the plastics manufacturing section of this factory on the 12th day of February 2024 on a monthly salary/wage of 40,000 naira. The claimant also averred that she had not yet been issued an employment letter before the unfortunate incident occurred that led to the loss of an upper right limb. Notwithstanding anything to the contrary, the law is that a contract of employment can be written, implied or oral. It was held in Umera and NRC. Citation provided, and I quote as follows. A contract of employment means any agreement, whether oral or written, express or implied, whether one person agrees to employ, whereby one person agrees to employ another as a worker and the other person agrees to serve the employer as a worker. A contract of employment is the foundation, the platform and pivot upon which a case is for wrongful or unlawful termination of employment by an employee against an employer can be founded or predicated, and its success or failure is entirely dependent on the terms and conditions agreed to by the parties in their contract for the employment. See Yere and BFFM, SSC and Afropac Nigeria Limited, Eden versus Unilorin, Ibana versus Shell Petroleum, Imolane versus Waik, UBN versus Ogodo, Amodu versus Amode, and also Section 91, Interpretation Schedule of the Labour Act. Therefore, it is only reasonable to hold that the failure of the defendant to issue the claimant a letter of employment will not in any way negate the case of the claimant, and any detriment, if any, on the absence of a letter of employment will be against the defendant in this case. Furthermore, the unchallenged averments in the statement of fact are coherent enough to establish that the claimant was a worker in the factory of the defendant, and hence under the employment of the defendant, even though the defendant did not enter into a written contract of employment with the claimant. On the relationship between the claimant and the defendant, I have no difficulty in finding that there is a contract of employment between the claimant and the defendant, and the claimant is indeed a worker of the defendant, I so hold. The gamut of this suit revolves around the alleged negligence of the defendant. To prove negligence, simplicity, a plaintiff must establish that the defendant owes him a duty of care, that he is in breach of such duty of care, and that the plaintiff suffered damages as a result of the defendant's failure or breach of that duty of care. See Igbe Renovo versus SCC and UBA and Achoro Adeshu Adeosun versus Adisa, and Okeke versus Abidife. Citations are all provided. On duty of care, the general requirement of the law, where there exists a service relationship between an employer and an employee, is that the employer is under a duty to take reasonable care for the safety of the employee in all circumstances of the case, so as not to expose him to unnecessary risk. The level of this duty is the same as that of the employer's common law duty, common law duty of care in the law of negligence. See Cabo Air and Mohammed, Aniyere versus BFFM, Adetona versus Edet. Citations are all provided. In alleging negligence on the part of an employee need not prove direct responsibility of the employer for the damage suffered. See Cabo and Mohammed Supra. Specifically speaking, the Court of Appeal held in Cabo and Mohammed Supra that it, and I quote, it is the duty of an employer acting personally or through his servants or agents to take reasonable care for the safety of his workmen and other employees in the course of their employment, whether the employer is an individual, a firm, or a company, and whether or not the employer takes any share in the conduct of the operations. This duty extends in particular to the safety of the place of work, the plant and machinery, and the method and conduct of work, but it is not restricted to these matters. See Iyerire and Bendel Feeds and Flour Mills. Citations are all provided. End of quotation. It was also averred in paragraph 5 of the statement of fact that the claimant worked in the trimming section of the defendant, where she was asked to trim bucket covers and install handles on the plastic buckets being produced in the factory. However, it was further stated in paragraph 6 of the statement of fact as follows, and I quote, when she reported to work on March 4th, 2024, she unexpectedly and without the required training asked to work in the section where the machine used in the fabrication of the bucket is located. Not having been trained on the usage and informed of the risks associated with the machinery, the claimant was unduly exposed to the danger and risk of the machine. End of quotation. It is apparent from the averments and evidence before this court that the defendant knew or reasonably ought to have known that the claimant's lack of training or experience as to the use of the machinery would inevitably lead to this event. When the claimant first reported her posting to the blue machine to another senior officer of the defendant failed or neglected to resolve the issue as reported in paragraphs 17 and 18 of the statement of fact. Continuing, the averments in paragraph 13, 16, and 19 of the statement of fact disclosed that the claimant had been assigned to night duties. Paragraph 19 is particularly disturbing, where it was stated as follows, and I quote, as a result of the above, for the period that the claimant worked in the defendant's factory before the injury that she sustained on March 4th, 2024, the claimant worked morning duty from February 12th, 17th, 12th to the 17th, night duty from February 19th to March the 2nd, 2024, making her work 2 weeks of night duty on a stretch. End of quotation. It is my view that the defendant further aggravated their breach of the duty of care to the claimant by assigning her to night duties at all, which action is a direct breach of Section 55 of the Labour Act, which prohibits and criminalizes the assigning of women to night duty. Further, it is true that the defendant initially took steps to assist the claimant by making a police report and taking her to Dave Star Hospital. The defendant thereafter failed and or neglected to come to the aid of the claimant. It was clearly the defendant's own negligence that led to the claimant losing her upper right arm and apparently her means of livelihood. The defendant, besides from the initial treatment, had a further duty of care to the claimant, which includes but is not limited to her proper treatment, recuperation, rehabilitation, and purchase of prosthetics, where such are demanded. It is therefore irresponsible on the part of the defendant to assume that a first line of treatment is all the aid the claimant should get. From the foregoing, there's no ambiguity as to whether the defendant breached their duty of care to the claimant. I hold, therefore, that the defendant was negligent and owed the duty of care to the claimant, who is a worker in the defendant's factory, and the defendant severely breached this duty of care, I so hold. Having considered all the evidence and averments before me, I have therefore resolved that the claimant has proved the case and the sole issue In this suit, it resolved in favor of the claimant. On relief one, the claimant claims for the sum of 2,600,000 naira for the procurement of prosthetics for the claimant's right hand. The evidence laid before this court that would support relief one must be with reference to Exhibit C5, which is the clinical assessment report dated the 24th day of May 2024 from Bold Care Prosthetics. It would be recalled that in paragraph 33 of the statement of fact, it was averred that upon receiving the quotation, the claimant decided to forward only the quotation from Bold Care Prosthetics instead of the ones issued by the other vendor, which were significantly higher. The said Exhibit C5, which has already been tendered in court, clearly shows a quotation of 2.6 million as the overall cost for the prosthetics by the vendor. The defendant refused and or neglected to pay for the prosthetics. In evidence, a document speaks for itself. See here this Nigeria Ltd versus GNICL Ltd, and also Ahmed and CBN citations are all provided. I have no difficulty in arriving at the finding that the claimant has shown sufficient particulars for the grant of relief one, and hence same is granted. On relief two, the claimant claims a sum of 150 million naira being compensation for the loss of the right upper limb and the consequential pain and trauma being experienced by the claimant. I have gleaned from the evidence and amendments before me, especially with reference to Exhibit C4, Exhibit C2, which indeed showed the claimant's injury and extent of damage. Additionally, the claimant physically showed to the viewing of the whole court her injury during a trial on the 26th day of March 2025. In Straba Construction versus Ogarekpe, citation provided, the Court of Appeal held that, and I quote, no principle can be laid down upon which damages of pain and suffering can be awarded by sheer calculation in terms of money for having been recognized as topic for the award of damages. The jury or the court must consider what compensation should be. However, awards for pain and suffering are usually generous depending on the event of the injury, depending on the extent of the injury and suffering that accompanied it. Obviously, they are awarded as general damages. See pages 754 and paragraph D to E. It was still further held in this case that, and I quote again, in personal injury cases, two main factors have to be taken into consideration in assessing damages in cases of liability. There are A, the financial loss resulting from the injury, B, the personal injury involving not only pain and suffering, but also the loss of the pleasures of life. However, to quantify the loss, whether financial or personal, is a difficult exercise. The court, in assessing the damages, proceeds with the underlying assumption that damages are compensation for injuries sustained and are not meant to be punitive. Again, damages are meant to be full and adequate. The fullness and adequacy of damages awarded as compensation will depend on proved solid facts of the case and a just and fair assessment of the effect of the injury complained of. End of quotation. Furthermore, in OK versus Kaja, citation provided, the Supreme Court noted some criteria in assessing damages related to personal injuries as follows, and I quote, it has been established by judicial authorities that in personal injury cases, two main factors are taken into consideration in assessing damages in cases of liability. These are the financial loss resulting from the injury, A, and the personal injury suffered involving not only pain and suffering, but also the loss of, B, the pleasures of life. The broad distinction between personal loss and financial loss runs through all the cases. Perhaps one of the most difficult exercises in assessing the damages is the quantification of the loss, whether financial or personal. Ediagbonya versus Dumez, citations are all provided. End of quotation. It would have been better if relief 2 were tied specifically to the cost of treatment and allied medical expenses already incurred or ongoing, notwithstanding a perusal of Exhibit C3 and C4, and I quote, acknowledgement copy of claimant's counsel's letter dated the 6th of May 2024 and 23rd day of May 2024 respectively, shows that the claimant's counsel specifically demanded the sum of 5 million naira only as compensation for the injury suffered by the claimant and payment to cover the medical expenses incurred already and ongoing medical treatment. The court prefers to be guided by this record. Relief 2 succeeds only to the extent that the court awards the sum of 5 million naira being compensation for the loss of the right upper limb and the consequential pain and trauma being experienced by the claimant. On relief 3, on the consequences of breach of duty of care, once the plaintiff has successfully shown and proved that he suffered personal injury resulting from the breach of duty of care owed to him or her by the defendant, the claim for pain and suffering must be considered by the court. No principle can be laid down upon which damages for pain and suffering can be awarded in terms of the quantum. When the totality of the evidence is considered and the peculiar circumstances of each case, the award is said to be generous, yet should not be excessively high or grossly low. See Ike Novo versus SCC Nigeria Ltd. Supra. In line with the foregoing, the court grants relief 3 to the sum of 8 million naira being damages for the breach of the duty of care by the defendant and the consequential pain and agony suffered by the claimant. In all, the case of the claimant succeeds only to the extent of the reliefs granted by this court. Judgment is accordingly entered. This is the judgment of the court between Mary Obochima and Ucheken Global Ventures Ltd.
As a complicity. My Lord, to express our sincere gratitude to the court for the judgment that has been just been delivered. We are most grateful, my Lord. Thank you, madam.
Okay. You can leave the meeting.
As a complicity, we are most grateful, madam. Thank you, madam.
Okay. Okay. Kadijat.
Yes, my lord.
Okay, you can call the next case.
Yes, my lord. NICN/LH/317/2023 between Ogechi Maureen Femi George and GPC Media Limited. My lord, parties absent.
Parties are absent. Appearances, please. Appearances.
May I please my noble lord, Momo San Kadiri.
Yes.
My lord, my humble appearance is for the claimant. I'm grateful, my lord.
Okay. Is the defendant counsel online?
Yes, I can see there's one of them here. I don't know if two of them are.
May the court be pleased. I am Tabe, appearing for the defendant. Holding the brief, my lord, I hold the brief of E. Ogbechi. My humble appearance is for the defendant.
Okay, noted. Yes, go ahead.
My lord, the matter is for adoption of final written addresses and subject to the convenience of the court. We are ready, my lord.
Yes, go ahead.
My lord, I think the defendant will have to go first by the rules of court. So I'll yield the floor to them.
Okay. Barrister Tabi.
My lord, we have the point of law to file, but as of yesterday, the registrars were still calculating the default fee, and we could not file as at yesterday. So we have it ready to file, my lord. My Lord, we're ready to file once the default fee has calculated and they get back to us today.
You are ready to file once the registry is able to calculate. Is that what you say? Able to calculate the default fees?
Yes, my Lord.
But I think that was the same excuse that was given at the last sitting. And that was about 10 days ago.
Oh, it's more than 10 days ago.
My Lord, we sincerely apologize for the delay. We had prepared it, but my learned counsel was unavoidably not available. But as at 2 days ago and yesterday, it was already with the registry, but they said until they calculate that the file was with my Lord, and they needed to access the file before they calculate the default fees. Thank you, my Lord.
So are you ready to adopt today?
My Lord, we are not ready to proceed because we need them to finish with the calculation of default fee, and we file before we proceed, my Lord.
Okay, Mr. Kadiri.
My Lord, I'm hesitant to say anything because I remember that last time when I expressed my displeasure at this sort of attitude, my Lord perhaps wanted to give them the benefit of the doubt. My Lord, I'm very disappointed that we would have counsel that I think it was in February, if not early March, my Lord, that we took the date for adoption of final written addresses in open court. And since that day, my Lord, to file their final written address, we waited until the very last day they didn't file, and we were constrained to then file because we didn't want to be, to be in default just simply because of their, I don't know what to call it. I'm trying to choose my words carefully, my Lord. My Lord, given the circumstances, a defendant that really, really genuinely has a reply to file on points of law, I would have thought that by now they would have taken the proper steps to do so. If the matter was adjourned over 2 weeks ago till today, it is disappointing to hear that it's only yesterday that they are now trying to take steps to calculate the default fees. So, my Lord, I will be asking that, given that they've already filed their final written address, with the greatest respect, my Lord, this matter is a very narrow point, which is, are they the employer of the claimant, or are they not? The issues have already been very well narrowed. And my submission will be, my Lord, that there is nothing more that needs to be added. Rather, they are just engaged in wasting precious time of this court, which, my Lord, cannot be permitted. This is the second time now they are coming to show complete indolence. And, my Lord, there are authorities that when a party, this is classic want of diligent prosecution, my Lord. And on that basis, my Lord, I'll be asking that the explanation provided by my learned friend is untenable. The issues are very narrow. They've been narrowed over and over again. And I will ask that they've already filed a final written address, which I will ask my Lord to foreclose them in terms of any further reply they want to file because of the attitude that they have shown so far. My Lord, those will be my humble submission, my Lord. I'm grateful.
Barrister Tabi, what do you have to say?
My Lord, I would like to crave the indulgence of my Lord that we have already written and the documents are available at the registry. It's just for us to get the default fee calculated and then we file. The documents are ready as of today for us to file, and we crave your indulgence, my Lord, that once we file, we're ready to proceed with the matter. Thank you, my Lord.
Can you adumbrate? I can give you that liberty on the points of law. You have already filed your final address. It's just the point of law. I can give you leave to adumbrate orally and adopt it. Are you
As
in
the
a
court
position
pleases,
to
my
do
lord.
that?
As the court pleases.
Mr. Ivor Tabi, are you in a position to do that? Mr. Ivor Tabi.
My lord, if my lord wants me to adumbrate vis-a-vis, I'm ready.
Okay, so we can go ahead and adopt then.
As the court pleases.
My lord, we're having a little network issue here. That's why I'm going off and on. But it's raining here in Ikeja. The network is unstable, but I'll try as much as I can to continue.
Yes, go ahead.
May I suggest that if my learned friend's video is on, perhaps if you turn off your video, it might enhance the connectivity slightly. May I seek my lord's leave, perhaps maybe if I don't know if I turn off my video as well, that would also help in terms of
No,
enhancing the connectivity.
no, the network challenge he has is from his own end, not from our end.
Oh, okay. I'm
Mm.
grateful, my lord.
At the moment, he has turned off his video, which is helping. So, Mr. Ivor Tabi, can you go ahead? Let's proceed quickly before the network knocks us off.
My lord, I'll go ahead with the reply of point of law. The claimant argued in the claimant's final written address.
Are you adopting? Hello, Mr. Tabi. Tabi, you need to adopt your final address first before we go to the reply. Do you have the process before you?
Yes, my lord, I adopt the final written address.
Okay.
Dated 6th day of May 2026.
Mm-hmm.
And I urge the court to
Go ahead.
and I urge the court to dismiss the suit for lack of credence and merit.
Okay.
Thank you, my lord. My
All
lord,
right.
I go ahead with the reply on point of law.
Yes, go ahead.
The claimant argued in the claimant's final written address dated 5th of May 2026 that the super screen television is merely a juristic person and must operate by a natural person or an artificial person.
Mm-hmm.
The claimant W1, while in the witness box, was asked of the assertion and whether she conducted a search with the Corporate Affairs Commission, CAC, but her answer was in the negative. The case is that he who asserts must prove by Section 137 of the Evidence Act in civil cases, the burden of proof is on the party who asserts a fact to prove same. My lord, we refer the court to the case of Dowd versus NNPC, 1998, 2NWLR, Part 538, 355 SC.
Yes.
On the claimant employment contract, it is written super screen television and nothing is written on the contract about it being a subsidiary of the defendant.
Mm.
The claimant assertion, therefore, amounts to asking this honorable court to speculate facts instead of doing justice in the matter. A party who seeks judgment in his favor is required by law to produce adequate and credible evidence in support of his pleadings or assertion. And where there is none, the averment is abandoned. We refer this Honorable Court to the case of Arabambi versus Advanced Beverage Industries Limited, 2005, 19 NWLR, Part 5, Part 959 SC.
Yes, go ahead.
Finally, my lord, the claimant assertion on the written contract between the Superscreen Television and GPC, the defendant hearing is not in question. The contract is not in contention and not challenged by Superscreen Television. What is in contention before this Honorable Court is the contract of employment between Superscreen Television and the claimant. The contract to train the employees of Superscreen Television and defendant is between the parties and the claimant. It's between the parties. And the claimant is not a party to it. It's a contract between the Superscreen Television and defendant relevant to the claimant. I take that again, my lord.
Quickly.
Is the contract between Superscreen Television and defendant relevant to the claimant to prove a case? The answer is in the negative, and we urge the court to so hold. The general rule is that where parties have embodied the terms of their agreement or contract in written documents, extrinsic evidence is not admissible to add. Is not admissible to add to, vary, subtract from, or contradict the terms of the written instrument. We refer this Honorable Court to the case of UBN versus Oziki, 1994, 3N WLR, Part 333, 385 SC, and NDB versus the Easy Life Electronics, 1999, 4N WLR, Part 597 BCA.
Okay.
In response to paragraph 5, sub 10 of the claimant's final written address, it strikes that no matter how beautiful a written address may be, it cannot be substantiated, cannot be a substitute for evidence. We so submit and urge this Honorable Court to so hold. Most grateful, my lord.
All right. Claimant counsel.
Yes, my lord. My lord, in compliance with the rules of this court, and despite the difficulties that and almost unfortunate situation that we found ourselves, because ordinarily the defendants was supposed to file their final written address before we did. But like I said, because the issues had already been pretty narrowed, we filed in compliance with the rules of this court, my lord. We filed our final written address on behalf of the claimant on the 5th day of May, 2026. It's dated and filed on the 5th day of May, 2026, my lord.
Yes.
My lord, I adopt the final written address as the argument and the case of the claimant in this matter.
Yes.
I rely on all the paragraphs, including the exhibits and documents referred to, my lord, including the authorities as well. My Lord, by way of brief adumbration, if I may, for a minute or two, my Lord.
Okay, briefly.
This case is a very simple case, my Lord. We have a case where the defendant has chosen to structure its affairs in a way that it pleases. And this is not unusual, where you have a company incorporated under KAMA choosing to use an unincorporated vehicle for whatever reasons best known to them to engage with certain individuals, including, in this case, the claimant. My Lord, whereas the defendant has continuously and consistently denied the existence of an employer-employee relationship, I am very confident that by the time my Lord takes time to go through the pleadings and all the processes before the court, that this sort of sham defense that we are seeing will be very clear to the court. My Lord, the crux of this matter is that you cannot have somebody who says they are not an employer, and yet they are carrying on certain activities that only an employer can carry out. For example, they have been paying, the defendant has been paying the claimant's salaries for a period of time. As Exhibit C7 shows, we addressed that at 5.10 in our written address. Beyond, my Lord, payment of salary to the claimant, the defendant more fundamentally deducted and remitted pay-as-you-earn tax on behalf of the claimant. They're doing that to the relevant tax authority. And indeed, my Lord, as we have submitted at paragraph 5.11 of our written address, under section 81 and 82 of the Personal Income Tax Act, the statutory obligation to deduct and remit tax only falls exclusively on employers. No entity or any person, third party, can do that on their behalf. And my Lord, we rely on the case of NDDC. Again, it's at paragraph 5.11, my Lord. NDDC versus ROSBIR.
Yes.
They also did the tax clearance, my Lord. They also did the tax clearance certificate for the claimant. Finally, my Lord, the so-called reliance on, because there are cases that they were only engaged to train the claimant, that they are not the employer. But my Lord, even up to this moment, and indeed throughout the trial, they have not exhibited the so-called purported training contract that shows that they were even engaged in that capacity. So, my Lord, once this sham defense of them not being the employer is removed, and I'm confident that my Lord will be able to see through that, then the gateway becomes open for the court to grant the reliefs that the claimant is seeking. My Lord, I would therefore be submitting that my Lord finds merit in this claim and grants the reliefs sought by the claimant, my Lord. Those will be my submissions, except I can be of further assistance to my Lord. I'm grateful, my Lord.
Okay, that's fine. That's fine. Khadijat. Registrar. Registrar. Okay. The case is adjourned for judgment, and the date will be communicated to parties. I think the registrar has been knocked off from the sitting, from the online sitting. So the case is adjourned for judgment.
We're
Hello,
most
my
grateful, my
lord.
Lord.
Okay, Khadijat, are you there?
Hello, my lord.
Yes,
Yes,
good.
my lord.
Okay, good. Give us a date for judgment.
24th August, my lord.
All right, good.
24 August, my lord.
Okay. So the
And
case
it's
is
going to be virtual, my lord, because the court will be on vacation at that time.
okay.
Yes, my lord.
My Lord, we are very grateful for the time and indeed the consideration and accommodation of the court. We are grateful, my Lord. I don't know if
Okay.
my Lord will permit us to be excused. And I want to also use the opportunity to wish my Lord a restful weekend.
Okay. Thank you. Yes, you
We're
can
most
leave the
grateful, my
meeting now.
Lord.
Okay, Barrister Tabi, thank you so much. Barrister Tabi, still go ahead, get the fees, get in touch with the registry, pay your default fees, and file your reply. Okay.
As the court pleases, my Lord.
Okay. So the
Most
case is
grateful.
that the case is adjourned for judgment to the 24th day of August 2026.
Thank you, my
Those
Lord. We are
details will
grateful,
be
my Lord.
sent to all parties at the appropriate time.
We are grateful, my Lord.
Okay, you can leave the meeting now.
Thank you, my Lord.
Okay, then. Khadijat, can you call the next case?
Yes, my lord. NICM/LA/193/2023 between Godfrey Idayen Edebo and Benny Brookstone Property Assets Management Limited and one another. My lord, I can't see parties online.
They are there. They are online.
Yes, my lord.
Yes. Appearances, please.
May it please the court. My name is Adebola Shobowale. My lord, I appear for the claimants.
May it please my lord, Olaide Adedapo. My lord, my appearance is for the defendant counterclaimant.
Okay, good.
My lord, the matter is slated for the adoption of final written addresses.
Okay.
Before we go on, my lord, we have one house cleaning application. We filed
Okay.
our reply on points of law out of time. We filed the motion for extension of time yesterday, my lord, dated the 21st day of May 2026. And subject to the convenience of my lord, we are ready to go on.
Dated when?
21st day.
2-1.
21st day of May 2026.
Okay, then. Mr. Adebola, will you serve with that application?
My lord, yes, my lord. No, we're not opposing the application, my lord.
Okay, good. So, Mr. Olaide, you can go ahead. Move in terms.
My lord, we move in terms of the motion on notice dated 21st day of May 2026 and urge the court to grant the relief sought therein as prayed.
Order granted as prayed.
Most grateful, my lord. My lord, we have filed our final written address in compliance with the rules of this court, and subject to the convenience of the court, we are ready to go on.
Okay, go ahead then.
My lord, the final written address is dated and filed the 14th day of April 2026. We seek to adopt and rely on the argument therein as the final argument of the defendant's counterclaimant in this suit, and urge the court to dismiss the claim of the claimant and grant the reliefs as sought by the counterclaimant.
Right.
My Lord, in response to the defendant, in response to the claimant's final written address, we also filed a reply on points of law. It's dated 21st day of May 2026, and it was also filed on the same day. My Lord, we seek to adopt and rely on the argument therein as the defendant counterclaimant's response to the claimant's final written address, and urge the court to grant the reliefs as such in the counterclaim and dismiss the claim of the claimant. Most grateful, my Lord.
All right.
My Lord, the claimant has also filed his written address, my Lord. The final written address is dated and filed on 12th May 2026.
Yes.
My Lord, we adopt the arguments contained therein as the claimant's final address in this matter. And my Lord, we urge the court to grant the relief sought by the claimant and dismiss the defendant's counterclaim in its entirety, my Lord.
All right. Khadijat, registrar. Registrar.
Yes, my Lord.
Okay. Give us a date for judgment.
My Lord, 24th August.
Okay.
My Lord.
Yeah.
My Lord, I am just wondering whether that date is not outside the 3 months prescription, my Lord.
Khadijat,
Hello, my Lord.
did you calculate?
Yes, my Lord. Yes, my
sure?
Lord.
Okay.
Yes, the date even falls on a weekend.
It's vacation.
So I decided to move it to Monday 24th.
It fell weekend what day?
Weekend on Saturday, August Saturday.
Yes, what date? What date was that?
22nd August.
Okay, then your counsel is right. If the 90 days was 22nd, you can't move it to the 24th. You go backwards instead. Do you understand it?
Yes, my Lord.
Mm-hmm. So we can take the 15th day of August.
So, my Lord, then I will need to change the one for the
Okay, so that was the same mistake. Yes, you have to get in touch with them and let them know.
Yes,
So
my Lord. Yes, my Lord. I'm sorry about that.
No problem. The case is adjourned for judgment 15th day of August 2026.
My Lord, but that 15th day of August too is a Saturday.
Okay, go to the Friday before then. That will be the 14th day.
That's the 14th day of August, my Lord.
Okay then. So, Lady, thanks for the observation.
As the court pleases, my Lord.
So the case is adjourned to the 14th day of August 2026, for judgment. Virtual will be virtual sitting and Zoom details will be shared to parties.
As the court pleases.
As the court pleases.
I'm grateful to my Lord.
Okay. So we can leave the meeting now.
Most grateful.
Khadija, any other matter?
No, my Lord, for today.
Okay, then.
We are done for today, my Lord.
Okay.
Yes, my Lord.
All right. So have a good day, counsel.
Thank you, my Lord.
Most grateful.
Okay.